To qualify for Medicaid, you must satisfy very complicated financial eligibility rules. Rules that can be traps for the unwary. One of the most significant traps is Medicaid's right to recover its expenses from your estate after you die, a practice known as estate recovery. Hi, I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth Metroplex. And today I'm going to share with you a trap for the unwary in Medicaid planning. Under current law, states are required to attempt to recoup Medicaid spending for long-term care services. Since about the only asset you're allowed to own and still get Medicaid coverage is your home, the right of the estate recovery program is the state's claim against your home. In other words, if you own a home, Medicaid is really a loan. It will pay for your care, but your house may have to be sold when you die to repay the state for the services it provided. Now, in Texas, the Medicaid Estate Recovery Program, commonly referred to as MERP, the state can only recover against assets in your probate estate. Now, there are exceptions to the state recovering. The Texas Department of Health and Human Services has set out some exceptions under which it will not pursue a claim. In probate, HHS is considered a non-secured creditor. It can file a claim against the estate, and if there are assets in the estate that can be sold to repay the debt, that property will be sold. So let's take a look at an example. Mary was in a nursing home and received Medicaid benefits which paid for her care to the tune of $100,000. Mary owned a home at the time of her death valued at $250,000. The state can file a claim to recover the $100,000 expended by it to care for Mary. If the only asset in Mary's estate is the house, then it will be sold to repay the debt unless an exception applies. The state gets the $100,000 back spent on Mary's care, and the remaining $150,000 would go to Mary's heirs. 5 elder advocacy groups are calling on Congress to eliminate Medicaid estate recovery, aka MERP, after a Congressional Advisory Commission concluded that the practice recoups only a tiny percentage of Medicaid spending while contributing to generational poverty and wealth inequity. In a jointly authored brief titled Medicaid Estate Claims, Perpetuating Poverty and Inequity for Minimal Return, the 5 organizations stated that the burden of estate claims falls disproportionately on economically oppressed families and communities of color, preventing families from building wealth through home ownership, which has been historically denied to communities of color through discriminatory public policy. They recommended that Congress should amend federal law to eliminate Medicaid estate claims. Alternatively, the law should be amended so that states have the choice of whether to use Medicaid estate claims as recommended in a report to Congress by the Medicaid and CHIP Payment and Access Commission, aka MACPAC. In its March 2021 report to Congress, MACPAC recommended that Congress amend Medicaid law to make estate recovery optional for states rather than required as it is now. The group, a nonpartisan legislative branch agency that provides analysis and recommendations to Congress, the U.S. Department of Health and Human Services, and the states, also recommends that HHS set minimum standards for hardship waivers under the Medicaid Estate Recovery Program. Currently, it's up to the states to decide what qualifies as hardship. The report points out that estate recovery recoups only about 0.55% of total fee-for-service long-term care spending. MACPAC recommends that states not be allowed to pursue recovery against any asset that is the sole income-producing asset of survivors, homes of modest value, or any estate valued under a certain dollar amount. In their issue brief, the 5 advocacy groups go a step further, noting that no other public benefit program requires that correctly paid benefits be recouped from deceased recipients' family members. They call for the elimination of estate recovery so that low-income families are better able to retain wealth and pass it on to future generations. or at a minimum, federal law should be amended to make estate claims voluntary. As elder law attorneys, we know a number of ways to protect homes from this kind of attachment. If you come to us before you anticipate needing nursing home care, we can preserve your home so that it's not in your probate estate. Now, there are multiple strategies available. However, each strategy comes with some risks that must be fully explored before determining the correct one. An overall plan that is tailored to suit each individual and to meet many contingencies as possible requires juggling a number of puzzle pieces. There is no one cookie-cutter solution. The key is to plan before you or your spouse may need nursing home care. As one piece in the overall picture of a balanced estate plan, we can help you save your home. We welcome the opportunity to work with you. You can contact our office to set an appointment. I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. I hope you found this content useful, and if you'd like to see more of it, please like my page, subscribe to this channel, and don't forget to tell your family and friends. Thanks for watching, and I'll see you next time.